The courtroom fell silent as Taylor Swift approached the witness stand. The fluorescent lights of the federal courthouse in Los Angeles cast harsh shadows across her face, highlighting a determination rarely seen outside her stadium performances. This wasn't a stage she had chosen, but it was perhaps the most consequential performance of her career. Ms. Swift, do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? So help you God? The clerk asked. I do, Swift responded, her voice unwavering. It was day 3 of what media outlets had dubbed the music industry trial of the century. Swift had filed a landmark antitrust lawsuit against 3 major streaming platforms, alleging collusion and price fixing that had systematically devalued artists' work across the industry. What began as her personal battle had evolved into a watershed moment for creative rights in the digital age. The judge, Eleanor Ramirez, a respected antitrust expert with 20 years on the federal bench, gazed impassively at Swift. You may proceed, counselor, she said to Swift's attorney. The courtroom was packed with music industry executives, artists who had rallied behind Swift, tech company representatives, and journalists frantically taking notes. Outside, hundreds of fans gathered despite the morning rain, many holding signs reading, "Artists deserve fair pay," and "Standing with Taylor." Swift's attorney, renowned antitrust litigator Catherine Chen, approached the stand. Ms. Swift, could you please explain to the court when you first became aware of what you believe to be coordinated pricing structures across these streaming platforms? For the next 40 minutes, Swift methodically outlined her case. She described discovering internal communications obtained through discovery that suggested executives from competing platforms had secretly coordinated to cap artist royalty rates. She presented data analysis showing statistical anomalies in payment structures across supposedly competing services. Most damning were the emails between platform executives that seemed to explicitly discuss maintaining what they called sustainable artist compensation models across the industry. What these documents show, Swift testified, gesturing to the evidence displayed on courtroom screens, is that while publicly claiming to compete with each other, these platforms were privately ensuring that no service would break ranks to offer artists substantially better compensation. They created the illusion of market competition while colluding to control the market. Swift's testimony resonated beyond the legal details. She spoke about young songwriters unable to afford rent despite millions of streams, about legendary artists seeing their life's work devalued, and about a creative industry increasingly unable to sustain the very people who create the content these platforms depend on. This isn't just about me, Swift emphasized, her voice cracking slightly with emotion. I'm fortunate enough to have the resources to fight this battle, but most artists don't. When these platforms coordinate to fix compensation rates, they're not just violating antitrust law, they're systematically devaluing creative work itself. Across the aisle, the defense team of corporate attorneys representing the streaming giants sat stone-faced. Their, strategy had been clear from opening statements. Characterize Swift as a privileged superstar, disconnected from market realities. Paint her lawsuit as the tantrum of an artist unsatisfied with her already substantial earnings. When cross-examination began, lead defense counsel Jonathan Michaels approached with calculated precision. Ms. Swift, he began, his tone performatively deferential. You've earned over $500 million in your career according to Forbes. Is that approximately correct? I've been fortunate, Swift responded carefully, but this case isn't about... Just a yes or no, please, Michaels interrupted. Judge Ramirez leaned forward. The witness may provide context for her answers, counselor. Please continue, Ms. Swift. Swift nodded. Yes, I've been successful financially. That's precisely why I believe I have a responsibility to challenge this system. Most artists cannot afford to take on these platforms. For the next hour, Michaels attempted to undermine Swift's credibility, suggesting her lawsuit was motivated by personal gain rather than industry reform. He highlighted her own streaming strategies, emphasizing how she had withheld albums from certain platforms to negotiate better terms. "So you've used your market power to negotiate preferential treatment," Michaels pressed. "Isn't that exactly what you're accusing these platforms of doing? Leveraging market position for favorable terms?" Swift leaned forward, unintimidated. "There's a fundamental difference between negotiating as an individual artist and competitors secretly colluding to fix prices. One is market competition, the other is market manipulation. The emails between your clients make that distinction very clear." The courtroom stirred at her response. Even some industry executives shifted uncomfortably as Swift referenced the internal communications that had become central to the case. As the cross-examination continued, Swift maintained her composure, referring repeatedly to specific evidence rather than allowing the defense to frame the case as her personal grievance. When Michaels attempted to characterize streaming revenue as fair market value, Swift countered with detailed analysis showing how coordinated pricing had artificially suppressed royalty rates compared to truly competitive markets. The testimony stretched into the afternoon. Outside, the crowd had grown, with artists from across genres arriving to show solidarity. Social media exploded with reactions. Music industry on trial trending globally. On cable news, panels of legal experts dissected each exchange. "What we're seeing is remarkable," commented entertainment law professor Elaine Harmon on CNN. "This isn't just a celebrity lawsuit. Swift has essentially built an antitrust case that the Department of Justice might pursue. The evidence of coordination between supposedly competing platforms is difficult to dismiss." By late afternoon, Swift's direct testimony concluded. As she stepped down from the witness stand, the weight of the moment was evident on her face, a mixture of exhaustion and resolve. The case would continue for weeks, with platform executives scheduled to testify next, but this day would be remembered as the turning point. That evening, commentary flooded media outlets. Supporters praised Swift's preparation and poise, while critics questioned her motivations. Industry. Publications noted that regardless of the outcome, the lawsuit had already forced unprecedented transparency around streaming economics. "What Swift has done," wrote music industry analyst Rebecca Chen for Billboard, "is pull back the curtain on practices that have remained deliberately opaque. Whether or not she prevails legally, she's already won in the court of public opinion by exposing how these platforms coordinate their approaches to artist compensation." Former streaming executive Michael Torres offered a different perspective on CNBC. "These platforms are operating in a complex marketplace with thin margins. What Swift characterizes as collusion could simply be parallel business evolution in a challenging sector, but perhaps the most significant reaction came from artists themselves." In the days following Swift's testimony, over 2,000 musicians from across genres signed an open letter supporting the lawsuit and sharing their own experiences with streaming economics. Grammy winners and bedroom producers alike described how the current system had made sustainable careers in music increasingly untenable. As week 2 of the trial began, the platform's CEOs took the stand one by one. Their testimonies revealed striking contradictions. Each claimed to operate independently, while unable to explain the remarkable similarities in their royalty structures and the damning communications between their executives. When StreamNet CEO Daniel Powell attempted to characterize an email discussing industry-standard royalty approaches as normal business practice, Judge Ramirez intervened directly. "Mr. Powell," she said, removing her glasses, "are you suggesting that discussing pricing structures with direct competitors constitutes normal business practice under antitrust law?" The CEO's hesitation spoke volumes. By the trial's third week, rumors of settlement discussions began circulating. The platforms, facing mounting public pressure and the prospect of damaging legal precedent, were reportedly considering significant reforms to their royalty structures. On the morning of what would have been the trial's 17th day, Judge Ramirez entered the courtroom with an announcement. The parties had reached a settlement agreement. The terms were unprecedented. The platforms agreed to a transparent royalty system with minimum per-stream rates tied to subscription revenue, elimination of algorithmic payola that had favored certain labels, and, most significantly, the establishment of an artist advocacy board with real oversight of future policy changes. At the press conference following the settlement announcement, Swift appeared alongside representatives from artist advocacy groups. This settlement represents a fundamental reset in how creative work is valued in the digital age, she stated, looking both exhausted and triumphant. For too long, artists have been told that exposure is compensation enough, that we should be grateful for platforms that distribute our work while taking the lion's share of revenue those works generate. Today marks the beginning of a more equitable relationship. The story dominated news cycles for days. Legal experts noted that while the settlement avoided establishing legal precedent, its terms would likely reshape industry standards. Technology analysts predicted the reformed royalty structures would force smaller platforms to adopt similar measures or risk artist boycotts. Senate Judiciary Committee Chair Senator Maria Rodriguez announced hearings on competition in digital content markets, citing the evidence revealed during Swift's case as justification for potential legislative action. What began as one artist's lawsuit has exposed structural issues that may require regulatory intervention, Rodriguez stated. When competing platforms coordinate approaches to creator compensation, we need to ask whether our current antitrust framework is sufficient. 3 months after the settlement, initial data showed promising changes. Average per-stream royalty rates had increased by 32% across major platforms. More significantly, mid-tier artists reported substantial improvements in streaming revenue, suggesting the impact extended beyond superstar performers. In her first major interview following the case with Anderson Cooper for 60 Minutes, Swift reflected on the broader implications. What this case revealed goes beyond music, she explained. It's about whether we truly value creative work in our society. When platforms that distribute content collude to minimize what they pay the people who create that content, they're not just violating antitrust law, they're making a statement about what they think creativity is worth. Cooper pressed her on what had motivated her to take on such a high-profile, risky legal battle at the height of her career. Swift paused, considering her words carefully. I've been fortunate enough to achieve financial security that most artists never reach, despite creating work that moves millions of people. That privilege comes with responsibility. If I wasn't willing to challenge this system, who would be? Sometimes you have to use your voice not just to sing, but to speak up when something isn't right, even when it would be easier to stay silent. The Swift case, as it became known, established a new paradigm for artist-platform relationships in the digital era. Beyond its immediate impact on streaming economics, it sparked a broader conversation about power imbalances between creators and distributors across creative industries. Law schools began teaching the case as a modern example of how antitrust principles apply to digital marketplaces. Business schools examined it as a case study in stakeholder capitalism and the risks of industry coordination in the age of digital transparency. Perhaps most significantly, the case inspired similar actions in other creative fields. Authors challenged e-book platforms, independent filmmakers questioned video streaming royalty structures, and digital artists examined NFT marketplace practices, all citing the Swift precedent. For the music industry specifically, the aftermath brought the most substantial restructuring of artist economics since the digital revolution began. While streaming platforms initially warned of subscription price increases and service reductions, most adapted to the new model while maintaining profitability, suggesting that fair artist compensation had always been compatible with sustainable business models. 1 year after the settlement, at a congressional hearing on creative economies in the digital age, economist Dr. James Henderson presented research on its market effects. What the Swift case demonstrates, he testified, is that market concentration doesn't just harm consumers through higher prices, it can harm creators through artificially suppressed compensation. When distributors coordinate their approaches to content acquisition, they're effectively forming a buyer's cartel, even if they never explicitly fix prices. The lesson extends beyond entertainment industries. As more of our economy becomes digital, as more workers become, in essence, content creators, the question of how platforms compensate the people who provide their value becomes increasingly central. Swift herself has spoken relatively little about the case since its conclusion, returning her focus to music. But its impact continues to reverberate. At the Grammy Awards ceremony following the settlement, host John Legend acknowledged its importance during his opening monologue. "Thanks to Taylor Swift," he said to applause from the assembled artists, "when we say, 'and the winner is tonight,' there's a better chance that the winner actually received what they've earned." In the end, Swift's courtroom battle represented something more profound than a contract dispute or even an antitrust case. It demonstrated how individual courage can challenge entrenched systems, how transparency can transform power dynamics, and how speaking truth to power can create lasting change. As streaming numbers returned to normal levels following the settlement, despite industry fears of platform abandonment, it became clear that consumers were willing to support systems that fairly compensate creators. The feared apocalypse of streaming economics never materialized. Instead, a new equilibrium emerged, one that recognized the simple truth that had motivated Swift's lawsuit in the first place, that the value of these platforms lies in the creativity they distribute, and that creativity deserves fair compensation. Perhaps the most fitting epitaph for the case came not from legal or business analysis, but from Swift herself, who added a brief coda to her final stadium show following the settlement. Before performing her closing number, she addressed the crowd. "When systems seem too big to change," she said as 80,000 fans fell silent, "remember that every significant change in history began with someone deciding that the status quo was no longer acceptable. Your voice matters. Use it." As the opening notes of her final song filled the stadium, the message resonated far beyond music. In an age of increasing corporate concentration and platform power, Swift's case had demonstrated that even the most entrenched systems can be challenged when someone with sufficient courage, resources, and moral clarity decides to stand up and say, "Enough."